primary role of any investigator is to gather and manage evidence in respect to the matter that you are investigating. The matter of evidence is extremely complex. However, you don't need to be a solicitor or know everything that a solicitor learns through their law degree. It is important, though, that you understand the importance of preserving the integrity of evidence. Incorrect handling of evidence can jeopardise future proceedings. You may start off doing a civil investigation for a workers' compensation matter, and during the course of that investigation you may find out that the claimant is lying. And this in turn may end up going towards a criminal investigation for fraud. So the better the evidence, the greater the chance of success. The best way to deal with gathering and managing evidence is to use best practice, and in using best practice that would satisfy what's required in a criminal court, it doesn't matter where your investigation goes, and it doesn't matter what forum or what environment that evidence is used. What is evidence? It is any material relevant to proving or disproving the matter that you are investigating. Evidence consists of facts and establishing facts, testimony, documents, exhibits, and anything else that you need that will be used by a court or tribunal to prove or disprove the matter that is under inquiry. You will have heard the term rules of evidence. The rules of evidence govern the introduction, admission, and exclusion of evidence in proceedings. Admissible evidence is evidence that complies with these rules of evidence so that it can be admitted in court or a tribunal to prove or refute the matter that's under inquiry. Rules of evidence can be different for different courts. That is, it depends where the evidence is being presented. For example, what is the difference between admissible evidence in a magistrate's court or in a more superior court, such as the district court or county court in Victoria, and the Supreme Court? And what is the difference between that type of evidence, which is admissible, and that is used in a coroner's court? In a magistrate's court or a criminal court, the main issue that you're trying to establish is guilt or innocence. And in a coroner's court, you're trying to establish the cause of death. And in establishing the cause of death, it may refer the matter to a criminal investigation and a criminal outcome because of the way that that death occurred. There's different types of evidence. By far, the most predominant evidence that you will use is direct evidence, which is testimony, and sometimes witness statements. You have real evidence or physical items that you're presenting in court. There's documentary evidence. Documentary evidence is real evidence or physical evidence. However, some documentary evidence is handled slightly different to any other physical items of evidence in that they don't need to be proven, or you don't need to establish exactly where those documents have come from. Proving a document is simply the matter of establishing who created the document, where it came from, and what context it was created. You also use photographs, videotapes, and audio tapes. The reason that you use photographs, videotapes, and audio tapes is to bring context to the matter that you're having heard in front of the court or tribunal. Photographs will bring the scene to the person who's making the decision about the outcome. Similarly with videotapes, if you look at where an accident happened, such as at an intersection on a road or on a bridge, how do you bring that to court? How do you bring that so that the decision maker can know exactly where it was that the event happened? Photographs and videotapes. You also have audio tapes. Audio tapes can give context into the way words are spoken. When you read a sentence, sometimes it's not immediately clear exactly what that meaning was. I'll give you an example. I never said he stole the money. Now that can be said in different ways. I never said that he stole the money. It may be I never said he stole the money. So if you look at the way that the words are spoken, it can give a different context and it can give meaning to what the words are that are used. There's a whole range of other types of evidence: expert evidence, circumstantial evidence, corroborating evidence, and hearsay evidence. Expert evidence is opinion, which normally you don't have in statements or in interviews. However, an expert, if they establish their particular expertise in a field, can give an opinion based on their expertise, qualifications, and experience. Circumstantial evidence is just a number of facts that are presented together where you draw a logical conclusion at the end. All evidence should be corroborated as best and as often as you can. Hearsay evidence is somewhat difficult. Our judicial system is the adversarial system. So you've got two sides that are adversaries to each other, and the evidence that's presented by either side of the proceeding, the other side has the right to challenge the evidence to make sure it's accurate and truthful. Hearsay evidence in criminal matters is not generally admissible. You have three main exclusions to the hearsay rule. One is a dying declaration, where someone on their deathbed in the very late stages of their life, the legal presumption is that they will not generally tell lies at that point in their life. You may have a matter that's reported to you that's in relation to a sexual crime. The first or most recent complaint in a sexual crime is hearsay evidence, but it is admissible because it's one of the exclusions to the hearsay rule. The anomaly with hearsay evidence for a sexual crime is the fact that it proves or establishes that the event occurred, but it doesn't prove who the offender is. And lastly, the most common type of hearsay evidence that you'll present in court is a confession. When you're interviewing an offender or an alleged wrongdoer in relation to a matter, they may admit to doing something wrong. You weren't there as the investigator, so what you're presenting is actually hearsay, but it's an exception to the hearsay rule. A confession is admissible in court so long as it's obtained voluntarily, and the person who makes that admission knows the consequences of what they've actually said, and they understand the consequences of how that conversation is going to be presented in court. Facts can be proved by one or a combination of the different types of evidence, and in reality you should attempt to prove facts in as many different ways as you can. The reason being, the defence counsel will try to eliminate or knock out all of your evidence throughout the process. So if you prove a particular fact in several different ways, you're never going to have all of those several ways that you prove that fact excluded as being inadmissible or not having any reliability. So therefore, in addition to witness statements, which is your most common and most prevalent type of evidence that you present in court, it is generally necessary to gather documentary evidence and real evidence that corroborate the version of events that's provided by the witness. It also confirms or disproves reasonable lines of inquiry in order to determine the causes of incidents and events. Statements should be clear in meaning. They should be concise and focused on the facts in issue. They should be relevant. They should be accurate. And they should be recorded as soon as possible after the event. The reason being, witnesses will have their version interfered with or contaminated by speaking to other people, or as time goes on, they may not remember as well as they would have immediately after the event occurring. The purpose of statements is to provide a word picture of a series of events used by police, claims managers, solicitors, prosecutors, court officials and jurors. So that word picture that's presented by a witness is usually supported by some other type of evidence, such as photographs and video or documents. A statement provides a guide for witnesses to base their testimony on. In a criminal court, if a statement is not quite strong enough in a particular area, when that witness is in the witness box, the prosecutor can lead the witness through the area that may be not covered sufficiently, and they will fill in those gaps and fill in the inadequacies of the statement by questioning in the witness box. The alternative, though, is in a civil matter, if a statement is not detailed sufficiently and doesn't cover everything as well as it should. The problem is most civil matters are settled out of court around a conference table where both sides to the action argue, negotiate and settle on the outcome, and they use documents predominantly for that. So if the statement is lacking, it's not going to be able to be rectified during that negotiation or settlement process. Statements also prevent changes of mind by the witness. If you have a witness who didn't see or hear anything, get a statement from them and lock them into that version of events. It restricts the fact that they can change their mind later, and if they do, there will be consequences in court regarding their credibility, and it will reduce their credibility. Statements provide a permanent record of events. Every document or object you wish to use in a court proceeding must be produced and presented by a witness in court as an exhibit. So statements should be obtained from the person who provides you with the exhibit, describing the item and the context in which it was gathered, and any other person that handles that exhibit before it goes to court needs to provide a statement to be able to prove what's happened to that document or exhibit in the journey between when it's been collected and when it's presented in court. You need to have the witness adopt and acknowledge the exhibit. It may be a previous statement if you're working in the civil sector. It may be a previous statement that's been taken by the police that's used and presented to you as a private investigator when you're investigating, say for example, a motor car accident. So the witness has to adopt and acknowledge the exhibit or document to say that that is the true and correct item and this is what's happened to it along its journey before appearing in court. The general rule in handling exhibits is to handle it as little as possible. It's important to retain the item as closely as possible to its original condition. Continuity is used to describe the handling and whereabouts of an exhibit or a document from the time that it comes into the possession of the witness until it is produced in court. Your continuity can also be referred to the chain of custody, the chain of evidence, or simply continuity. It has to be proven that the exhibit before the court is the same exhibit that was referred to by the witness and that it hasn't been changed or tampered with while being retained for court proceedings. Exhibits must be correctly labelled, including the description and identification details of the exhibit, the time, date and place that the exhibit came into your possession, where it came from and from whom it was obtained. So in a summary, correctly obtained, labelled and handled exhibits are vital for the success of any proceeding. It is often difficult to predict how or where the evidence will be used in the future. 5 best tips on gathering and managing evidence. Make notes. Your notes must be accurate, taken at the time, and if you're using individual sheets of paper rather than a bound book with numbered pages, your evidence and your notes must be signed with the date and time on them. Don't touch exhibits until you photograph them in situ. And take a moment to consider the best way to handle the evidence or the item to preserve its integrity before you move it or you take it into possession. Handle exhibits as little as possible. Everyone who handles an exhibit must give a statement before they go to court to say what their involvement is in the handling of the exhibit. Similarly, if you've got an exhibit that needs to be handed to different people, such as it might be a video that needs copying or a sample of water, for example, that may need to be examined by a scientist, try and handle the exhibit just on your own. Don't have different people handling it because they've all got to make a statement. Whereas if you're the only person that handles the exhibit, or the term I use is an evidence custodian, you only have one statement to prepare before the court proceeding. Your exhibits must be correctly labelled and identified so it differentiates that exhibit from another exhibit of a similar type. The last point is if you're in doubt about whether you should take possession of a piece of evidence or not, include it. If necessary, it can be excluded later on or handed back to the person from whom you took it from. You may only get one chance at gathering that evidence, so therefore, if you're in doubt, gather it and make the decision later.